Hello, I'm Terrie and I am attorney Brandon McGee's certified paralegal, and I'm going to talk to you today about the legacy wealth planning portfolio that our clients receive. So when you do your documents with us, you receive this wonderful notebook full of your documents. It's important that you realize these are all of your original documents, and you will need some originals down the road with everything. Now, the first thing inside of this notebook is the table of contents, and it's going to have everything within here. It's going to talk to you about what is in here. Then you're going to have your trust information. What makes it important for you to realize is that when you see a page inside of your portfolio with a long black line, this explains what everything is behind this section. It is written in terms that everyone can follow and understand. So you, as the trustor, the person who sets up the trust and serves as the trustee of your trust during your lifetime, can easily reference everything and go, oh yes, I remember. The other important thing about this page is it tells your successor trustees what's going on. So inside of your wonderful notebook, you will have a copy of your living trust, and you will see that this section is one of the largest sections in here. Why is it so large, everybody asks? My life is not complicated. This is a well-written trust, and Attorney McGee makes certain that it is well written and it covers all of the things that you may or may not have happen in your lifetime or after your lifetime for your trust. It's better to have all the what ifs in there than to need something and it not be in there. So he does include all of those things. The next section talks about your trust property. And this is where you keep track of your assets that are within the trust. Remember that if the trust is not named as the owner or the beneficiary, it is not a trust asset. So if you leave an item payable on death or as a beneficiary designation, it is not controlled by your trust. You will recall that when Attorney Brandon McGee went over the funding of your trust. Next is your pour-over will. Everybody goes, I have a trust. Why do I need a will? What if? What if you do not put something in your trust, did not leave it with a designated beneficiary or a payable on death beneficiary, then that asset has to somehow get poured over into your trust. So your pour-over will is going to be behind this section. And then next is your funding instructions. You have a trust. Now how do you fund it? We're going to hold your hand and work with you through the funding. But we have people who get home, and this happens all too often, they're like, now what did he say? What did Brandon say? You can reference this page right here, your funding instructions, how to put assets in the name of your family trust, general instructions for the transfer of existing assets, how to do real property. It covers it all. How to take care of stocks and bonds. Everything is right here for you. Your certificate of trust is next, and that is what you're going to use every day working with funding your trust. Someone's going to ask you about your trust. You do not have to. Remember the size of your trust? A couple of tabs back? You're not going to have to present that. You're going to just present the certificate of trust. That's going to have your trust name, when it was established, who's the initial trustees, the trustors. It's very concise with everything you need. Then you're going to have a section to include for your life insurance. That policies, policy numbers, where all of that is located. Then you're going to have a section for list locations. People think, well, everything's in my phone. Well, guess what? What if your phone gets lost? What if someone can't crack the code to get into it? They need to know who is your representative, who's your financial advisor, How do I call Aunt Sally? All of those people and everything for your list. Where are your tax records located? Where are your banking records located? Your list section covers that. Now we have the property power of attorney. That is your statutory durable power of attorney and your property power of attorney. Those are both financial powers of attorney. This allows when you are incapacitated but still living, remember keyword, still living, for your designated agent to take care of your financial matters. It is important to note that upon your death, these documents are no longer valid. A statutory durable power of attorney and a property power of attorney dies when you die. The next section is your healthcare section. Well, who can take care of you when needed for your healthcare? You'll make all your healthcare decisions until the day comes that you're unable to. You have a stroke, you're in a bad accident. Your agent will be able to get your medical records, talk with doctors, have a HIPAA release in there, which will get the medical records. Your healthcare documents include things that we haven't even thought about before. How about your declaration of guardian in the event of incapacity, or declaration of guardian for a minor child in the event of incapacity? Because your will only designates that person when you're dead, not while you're alive and incapacitated. You also, too, are going to have a page in here for your burial and funeral instructions, because even though it might be listed inside of your will, someone needs to be able to take care of that before you go through probate. Probate can take several weeks up to several months if needed. So we have all of that in behind with your healthcare documents. The next section is other documents, birth certificates. You're going to put in there baptismal certificates, marriage license, divorce decrees, death certificates of other people that are important in life that have come across. Might be a spouse after the first one dies, passport, driver's license. All those important pieces of paper go there. And then, how about instructions for your representative? What happens in the event of death or disability? We have instructions, and we have a 14-point checklist for your representative or your spouse in the event of death or disability. Coming to the end of the notebook is something that people go, oh, I don't really need that, but let me tell you, it means a whole lot. It is called your legacy plan. It talks about, how did you meet your wife? How many times have you wished your grandparents or your parents had written down this information? But if somebody gave you the opportunity to write yours down and they handed you a blank piece of paper, you might return them that blank piece of paper. But how about something for prompts? How did you meet your spouse? Where did you go to school? What was your favorite subject? What Christmas memories do you have? I have wonderful stories that I see all the time with clients who fill that out. They share that every time with their family members. It could be that secret recipe for that lemon pie that mom makes that she hasn't shared with anybody, and you find it tucked in there. And that's a true story. We had a client whose mother, they had thought taking that pie recipe to her grave, and lo and behold, it was in her legacy part of the notebook. The other part of the notebook includes your letter to your representatives and your family. It also includes a section to include very specific gifts. How about the turkey platter that your daughter wants? But it's not something that has to be listed throughout. It's just you're acknowledging she wants that turkey platter and you want her to have it. Well, that's a very quick run through of our legacy notebook. When you come in, we go through it with you, but we also too send you home with all of the directions throughout it, and you have the opportunity to read it and ask additional questions after you leave. Thank you.